Good day, class. Today, under the Human Resource Management, Gaining a Competitive Advantage, on Chapter 3, we'd like to be tackling the legal environment, equal employment opportunity, and safety. So there, no. So the chapter will give us, the learnings about identifying the three branches of government and the role each plays in influencing the legal environment of human resource management. And then another one, the chapter will be tackling about the major federal laws, because we're giving or getting examples coming from the Western world, the U.S. and the Northern America, supposedly. So federal laws would be the basis of it, but then apparently I'll be trying to relate it to the Philippine law context, because our constitution somehow are based mainly, supposedly, and patterned after the U.S. or federal laws. So the federal law that will require the equal employment opportunity and the protections provided by these laws. Now, another learnings that is expected for us to impart this afternoon or this day is the roles, the responsibilities, and requirements of the government responsible for enforcing equal employment opportunities for everyone. And then the rights, the Civil Rights Act, applying the theories to different discrimination laws that are abound, in the industry right now. Now the chapter will also try to discuss the legal issues that involve with preferential treatment programs, and then identifying even the behavior that constitutes sexual harassments, and list things that an organization can do to eliminate and minimize it. It also identifies some of the provisions of the laws for occupational safety and health. There. Now, to start with, the legal system in the Philippines context, or in the U.S. per se, are we have the three branches. So what are these? So first is the legislative branch, and then the executive branch, and then the judicial branch. So in the U.S., the same thing, as with us here in the Philippine Constitution. Three branches: legislative, executive, and the judicial branches. Now, these branches takes care of the policies through laws, through bills, through ordinances. So they come up with the bills and ordinances and laws that would somehow focuses on the equal employment opportunity. Now we define what is equal employment opportunity. Now the government attempt to ensure that all individuals have an equal chance for employment, regardless of race, color, age, gender, or national origin, religion even, and also there. Okay, so that's important of it. Now, another definition of the equal employment opportunity. Equal employment opportunity, it's a government attempt to ensure that all individuals have an equal chance of employment. So again, what are the constitutional amendments, or inclusions? In the U.S. is the 13th Amendment, they call it. So what does 13th Amendment tell us? So in the federal laws, it is the abolishment of the slavery. So remember, 13th Amendment abolished slavery. Now in the 14th Amendment, it forbids the states from denying equal protection of the laws. So there. The Congressional Legislation, however, is the Reconstruction Civil Rights Act. It was put into law in 1866 and 1871. You're talking about the federal laws here. And the Equal Pay Act of 1963. Equal Pay Act. Okay? And then the Title 7 of the Civil Rights Act of 1964. So if you're going to be noticing from the 18th century to the 19th century, so the laws, the congressional legislation are dynamics, no? So they kept on, changing and adapting to the times. Now, the Age Discrimination in Employment Act of 1960 was introduced in 1967. There, no? So these are the congressional legislation. And then came the Vocational Rehabilitation Act of 1973. The Vietnam Era Veterans Readjustment Act of 1974, consequently, no? So there, because there was a war during that time, now the U.S.-Vietnam War. Now, the Pregnancy Discrimination Act also were introduced during those era. The Civil Rights Act of 1991 were introduced, no? So that's already 1991. And then Americans with Disabilities Act were also introduced because of the casualties of the war and the congenital conditions of some individuals. So it was introduced in 1990, Americans with Disability Act. Now, for the executive orders, there is the Executive Order 11246, and it prohibits government contractors from discrimination. So there, no? So, and then even the Executive Order 11478, it's a government employment policies based on merit and fitness. So you see the difference, okay? Now, enforcement of equal opportunity, equal employment opportunity comes along in two agencies that are responsible for the enforcement of these laws and executive orders. So, number one is the Equal Employment Opportunity Commission. And then the other one is the Office of Federal Contract Compliance Programs. In the Philippine context, it is under the labor laws. So, the Department of Labor and Employment. So, there, more or less. The Equal Employment Opportunity Commission has three major responsibilities. So what are these? Number one is investigating and resolving discrimination complaints. Number two is gathering information and then issuing guidelines based on the collected information. Now, the Office of the Federal Contract Compliance Program has three components. What are these? Number one, utilization analysis. Number two, goals and timetables. And number three, action steps. Now, the Office of Federal Contract Compliance Program also annually audits government contractors if they are compliant with the rules engaged by them. Now, we now define what kind of discriminations do we have. So we have different types of, three types of discrimination. So number one is the disparate treatment. And then the disparate impact. And then the reasonable accommodation. Okay? Now, we try to define each. No? So the disparate treatment is defined as disparate treatment exists when an individual in similar situations are treated differently. And that treatment is based upon race, color, religion, sex, national origin, age, or disability status. Okay, so that is disparate treatment. Or otherwise, the bona fide occupational qualification, the BFOQ. Like, for example, in the cases of McDonnell Douglas Corporation versus Green. So, we can check that out later on. However, the disparate impact is defined as the disparate impact occurs when a facially neutral employment practice disproportionately exclude a protected group from employment opportunities. So it's the 4/5 rule, the standard deviation rule, and there are cases, and I want you to work on this, the Wardco Packing Company versus Antonio, and the Griggs versus Duke Power. Okay, so there, no? when a facially neutral employment practiced disproportionately excluding a protected group. For example, native from a group of native from coming from that province, from that area, from that origin, so being excluded based on race. Now, the reasonable accommodation as a discrimination is places a special obligation on an employer to affirmatively do something to accommodate an individual's disability or religion. Okay, so that is reasonable accommodation. For example, the religion and accommodation, and disability and accommodation. So there, so reasonable accommodation, we call it. Okay. Now, the retaliation for participation and opposition. There's a law, state law that entitled Title 7 states that employers cannot retaliate against employees for either opposing or a perceived illegal employment practice or participating in proceeding related to an alleged illegal employment practice. So that is retaliation for participation and opposition. However, employees do not have an unlimited right to talk about how racist or sexist their employers are. So therefore, there is a certain restriction even in that context. Now, the current issues regarding diversity and equal employment opportunities are sexual harassment, affirmative action and reverse discrimination, and outcomes of Americans with Disability Act. Okay? Now, we define what is sexual harassment. It refers simply to unwanted sexual advances by the stakeholders. We called it kid pro quo harassment, kid pro quo harassment by Bondi and versus Jackson is one of the cases. A hostile working environment is also part of it. So there's a case between Ron Clark Ford of Amarillo, Texas, and Babies R Us as a company. Now, there are three critical conditions for sexual harassment. So number one, the plaintiff cannot have invited or incited the advances. And then harassment must have been severe. And then number three, the court must determine the liability of the organization for actions to its employees. And then preventive steps for firms include development of a policy statement, training in inappropriate behaviors, development of a reporting mechanism, and disciplinary policy. Now, the affirmative action and reverse discrimination was conceived as a way of taking extra effort to attract and retain minority employees. So that is affirmative action and reverse discrimination. It also imposes quota programs. Now, the entire debate over the affirmative action continues to invoke wide attention. So there. And now, the outcomes of the Americans with Disabilities Act. So we relate to that in the American context. So under that Disabilities Act, a firm must make reasonable accommodation to a physically or mentally disabled individual unless doing so would impose undue hardships. So then, detrimental to the health and welfare of the disabilities. Now, under that firm, under ADA, we call it ADA, Americans with Disabilities Act. Under it, a firm must make reasonable accommodation to a physically or mentally disabled individual unless doing so would impose undue hardships. The consequences of this act are increased litigation, and then cases being filed do not reflect congressional intent. And then the act was passed to protect people with major disabilities. And then the law has not resulted in a major increase in proportion of people with disabilities who are working. Now, we tackle the employee safety. So, employee safety is regulated by both the government, no, and the state government, the national government and the local government, no, in our case. Now, the occupational safety and health is the general duty clause. Okay. Under the OSHA, no, so the one described a while ago or defined a while ago, the employees have a right to request an inspection, have a representative present at every inspection, have dangerous substantial or substances identified, have dangerous substances, could be drugs, no, or any hazardous elements, no, and then by promptly informed about exposure to hazards and be given access to accurate records regarding exposures, chemicals, no, those things, no, and then have employer violation posted at the work site. So these are the employee rights, that they should be informed about the presence of these elements. Okay, so what are the citations and penalties? The OSHA inspections are conducted by specially trained agents of the Department of Labor in the U.S. No, so probably we have it all here also, no, in different agencies, the Department of Health, the Department of Labor, and they are called compliance officers. Now, these are trained agents of the Department of Labor and called compliance officers now for the rules and policies being engaged by the government. Violation results in a citation to the employer, so they will be given citations. And then, and then from there, the criminal and civil penalties will be imputed if they found, if they have found violated these policies and rules and regulation and laws. Now, the safety awareness programs attempt to instill symbolic and substantive changes to a safety programs. And there are three primary components of the safety awareness program. Identifying and communicating job hazards is number one. What are these? Now, job hazard analysis technique or technique of operations review, reinforcing the safetiness practices or the safe practices, and then promoting safety internationally. And these are basically, has the context of chapter 3. So the legal environment, equal employment opportunity, and safety for its employees. And it is important for everyone, organizations, businesses, employees even, to know their rights based on the prevailing laws. In the Philippine context, the laws that are in is very strong right now because there are lots of congressional passing of laws, and even local government through ordinances and are doing their best not to protect our workers. So the Congress and the Senate are also helping hand in hand for them to be able to come up and craft bills that would protect the working class in the Philippine context. More so, the adaptability of the national laws are now being carried out in the local government units. So the executive body, the legislative body through the ordinances and ordinances are being induced, and then from there, upon the approval, is now being passed on to the executive body for implementation. In that case, now from the councilors of the city or municipality to the mayor of the city, now to carry on what was passed upon to protect the labor. So therefore, Chapter 3 actually, class, will give us an ample knowledge about the legal environment and the equal employment opportunity and safety. There are lots of violations right now that are going on, even with the strength of the policies, laws, and regulations that are being introduced by the measured by the government. So there. Okay, so again, thank you very much, class, for listening on the chapter 3 under Human Resource Management, Gaining a Competitive Advantage. Chapter 3 tackles about the legal environment, equal employment opportunity, and safety. Have a good day and thank you very much.